Parliament cannot convert itself into a constituent assembly. Whereas the Indian Independence Act 1947 provides that as it's obvious Mullah's 15th August was independence. He did not immediately accede. All the other Maharajas acceded apart from those two, Junagadh and Hyderabad. He never wanted to. It's only in October that this happened.
नाज़रीन, आज सुप्रीम कोर्ट ने दफ़ा 370 की मनसूखी को चैलेंज करने वाली तमाम दरखास्तों की समाअत शुरू कर दी है। वाज़ेह रहे 5 अगस्त 2019 को मरकजी सरकार ने जम्मू कश्मीर को खुसूसी दर्जे देने वाले आर्टिकल 35A और दफ़ा 370 को मनसूख कर दिया था। मेंबर पार्लियामेंट अकबर लोन बारामूला की नुमाइंदगी करने वाले कपिल सिब्बल ने भी अपने दलाइल का आगाज़ किया है। उन्होंने कहा कि 1956 में तहलील होने वाली आईन साज असेंबली को ही आर्टिकल को मनसूख करने का इख्तियार हासिल था, इसीलिए इसकी मनसूखी गैर कानूनी है।
The clauses of this article we have provided for concurrence of the government of the state. The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. Well, what can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to.
Once the Constitution is drafted, once it is come into place, then all institutions under the Constitution are governed by the Constitution. And those institutions are limited in the exercise of their powers, because they have to exercise their powers consistent with the provisions of the Constitution. Parliament cannot convert itself into a constituent assembly. That's done. Today, the Indian Parliament can't say by a resolution that we are the Constituent Assembly. As a matter of law, they can't say it, because they are now cabined, cribbed, and confined by the provisions of the Constitution. They can't pass a law which is outside the list. They can pass a law under 254. If the state passes a law, it's repugnant. They must adhere to the basic features of the Constitution. They can't suspend, except in emergencies where external aggression, the fundamental rights of people. That also is limited under provisions of the Constitution. The executive can't do things which are contrary to the law, and the judiciary then declares the law. But no parliament can convert itself into a constituent assembly. And if you accept that proposition of, whereas the Indian Independence Act 1947 provides that as it's obvious Mullah's 15th August was independence, he did not immediately accede. All the other Maharajas acceded apart from those two, Junagadh and Hyderabad. He never wanted to. It's only in October that this happened. Whereas the Indian Independence Act 1947 provides that as from the 15th day of August 1947, there shall be set up an independent dominion known as India, and that the Government of India Act 1935 shall, with such omissions, additions, adaptations, and modifications as the Governor General may by order specify.
Clause 2, not with reference to
Yes,
clause 3.
yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm saying, I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir, but that cannot be a permanent feature of the Constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met, and taken its decision both on the constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. Well, there can be nothing clearer than this. I mean, we in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. Next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India, will be a unit of the future Federal Republic of India, and the Union Legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later addition with the concurrence of the government of the state, and steps have to be taken for the purpose of convening a Constituent Assembly in due course, which will go into the matters I have already referred to. When it comes to a decision on the different matters, it will make a recommendation to the President, who will either abrogate 306A or direct that it shall apply with such modifications and exceptions as the Constituent Assembly may recommend. That, sir, is briefly a description of the effect of this article, and I hope the House will carry it. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our